place there.
Ok. Juste mon verre, good evening, ladies and gentlemen. Good evening, dear students. And also good evening to the ones who are following us on live stream. This is a quite special day, as you know. It's a Human Rights Day, but it's also a day where a lot of things are happening in Geneva. Nice things like conference up there, and less nice things since I just say it for the people who are on live stream. There is an ongoing terrorist threat in Geneva, and news are quite contradictory. But we did it here. I don't know if some police is around us. We just asked the police to come and watch over this event since it's on the war. But I don't know if they did it because they said there were so many requests of protection that they couldn't ensure that they would be here. Anyhow, let's forget this and let's enjoy this panel. This is the third edition of the War Report, and I'm happy to show it to you. Unfortunately, there are only 4 copies of this book. You have seen 2 outside. Here is the third. I don't know where the fourth is. It has been prepared these last days, and we're happy to have it. It's quite a heavy book, as you can see. It's also the third launching event. We have a new editor of the book, Anissa Bellal, a new moderator for this debate, Romain Jean, whom I thank. And I have the pleasure to underline that it is a female-dominated panel. The structure of the War Report is unchanged. First, you will find legal definitions and methodology, and I will come back to the methodology in a few minutes. Then you will read analysis of situation of armed conflict, situation by situation. And thirdly, a range of essays on some hot topics like refugees under international humanitarian law, and 2 contributions whose title I quote, Engaging with Drug Lords, Colombia, Honduras, and Mexico, or Youth as Main Victims and Main Perpetrators of Violence. So a lot of essays with quite original topics and quite original titles. You have also figures in the book. The authors have identified 3 international armed conflicts in 2014, 29 non-international armed conflicts, sometimes in the same countries, the so-called fragmented conflicts, and 10 situations of occupation. So overall, 42 situations where different branches of international humanitarian law apply, keeping in mind, as the authors do, that international human rights law also apply in these situations. Specialists have calculated the number of casualties following their own methodology. 4 conflicts have come to an end in 2015. The figures are more or less similar to last year. An important point which has been emphasized last year in last year's discussion is that since these topics are controversial and trigger major consequences, the editors, Stuart Kazimeslan and now Anissa Bellal, have from the outset displayed the methods they have been following and the definition they have decided to refer to, and submit this decision to an open discussion. This is exactly the opposite of a dogmatic closed approach, which would be based on the assumption that we know. We are not dogmatic and we are independent, which is what is published today is an entirely independent legal analysis of a field where politics and advocacy play a major role. So to take the definitions and the Idealtypen from Max Weber, it's really a work of science and not a work of politics. Why is this work important, if I may comment on this? Obviously, a qualification as armed conflict triggers important consequences for the population concerned, which enjoy specific protection. It also allows combatants or persons participating in the hostilities to undertake actions which will not be unlawful under AHL, because the actions are part of the conflict. Many of you were present at the launching of the new commentary on the Geneva Conventions, launched under the auspices of the Academy last Friday, or I followed this event online. They will remember that one of the panelists, Klaus Kress, underlined the importance of a sentence by Andrew Clapham in the commentary, and I want to quote this sentence in order to connect also this first event with the second. And I quote Andrew Clapham, I quote Kress quoting Andrew Clapham, "The humanitarian imperative pulls us towards adopting a low threshold of violence for ensuring the humanitarian protection of the Geneva Conventions. But there is a risk that this low threshold gets misapplied to determine the existence of a right to use force in self-defense or the application of the wider law of armed conflict, thus escalating the violence and putting even more people at risk. In other words, the qualification of a situation of violence as an armed conflict shall not be overused or misused and has many consequences. It reminds us that all the dimensions of the work of classification which is presented here and submitted to a public debate shall be taken into consideration. What are the next steps? With the support of its donors, first of all the Swiss Ministry of Foreign Affairs, which I would like to thank warmly for the support they have given to this report and all the activities of the Academy, even if they could not be, unlike for the last editions of the war report, they could not participate in the panel because of an extremely busy schedule. With the support of the Swiss Ministry of Foreign Affairs, the Academy will dedicate a lot of efforts next year in order to renovate the war report, which will be published under a new formula and perhaps a new name. The renovation will be done in coordination with the releasing of the new version of the traditional website of the Academy on the rule of law in armed conflict, RULAC, which will be launched in the first weeks of 2016. Let me finally thank a series of persons and institutions. I have already mentioned the Ministry of Foreign Affairs of Switzerland. I would like to thank Oxford University Press, which has published this third war report. The editor is on the podium, Anissa Bellal, and I would like to publicly express my gratitude to her. She has performed a wonderful work in conditions which are not the most comfortable sometimes. All the contributors, some of them in the room and some behind the screens, I guess, I like to thank. I would like to thank the panelists of tonight and the moderator, Romain Jean. Finally, the wonderful staff of the Academy, Nathalie, Tatiana, Camelia, Dani, Antonella, Daniela, without which neither the publication nor tonight's event would have been possible. And finally, Louis-Jean and his colleague, whose name I don't know, who are managing the live stream of this event. That having been said, I give the floor to Romain Jean. Thanks for being the moderator of this panel. Yes, tu veux le... And the book is given to the editor. The third copy.
Est-ce que ça marche? Voilà.
First copy is here.
Thank you and good evening. I'm very glad to be here tonight for this war report. Great opportunity to reflect about the violence, the situation of violence in the world, especially tonight in Geneva, a city on high terrorist alert, but police said, but I think everything will be okay. We are very interested to listen our panelists tonight. Thank you for having accepted the invitation of the Academy. I am myself chief editor at the Swiss TV and president of the Fondation Hirondelle. We create independent media in the conflict area. We are present in Central Africa, in Mali, in Bukavu, in South Sudan. Many countries present in this war report. It's an open discussion. I will give you the opportunity later to ask questions to our guests. And as said, this debate is live streamed. We hope it will be some question on some on internet user can react, ask question, tweet on our hashtag. With us tonight, Ms. Anissa Bellal, who assumed this year's edition of the War Report, Mr. Christoph Heinz, which is your professor of human rights law in Pretoria, Ms. Cordula Droege, head of the operational law unit at the Red Cross, Ms. Cecile Aptel, UN High Commissioner for Human Rights. I make your CV a little short, but excuse me, I will present you later. Thank you for being with us tonight. And the first contribution will focus on the changing nature of armed conflict. As said, we had last year 42 armed conflicts, but only 3 were international armed conflict, and a significant increase of people killed, 171,000 people killed or injured, and we had naturally the rise of the Islamic State. So, Ms. Anissa Bellal, you're the right person to speak about the situation of armed conflict. You were You assumed this war report. You are from the Geneva Call. You were working in the past at the Academy, at the Geneva Academy, for the Swiss Department of Foreign Affairs, for the Red Cross too, I think. Huh? Okay, I let you the word for this report.
Well, thank you very much. Good evening, everyone. Thank you for coming to the launch of this book tonight. Despite the threat and...
I think your microphone is not on.
Okay. So thank you again for coming tonight to the launch of this book, which I had the pleasure to edit for this year. Before talking about the topic, I also would like to thank 2 persons who are not here tonight, but who helped me a great deal to work on the book. Sarah Larocca, who is, I think she's now in the Philippines, but I'm not very sure, and Mayang Verma, who are my 2 assistants for the edition of this book. Without them, I could really not have done it properly. And of course, I also would like to thank the authors of the different chapters. That said, I wanted to talk to you tonight about the changing nature of internal armed conflict. As you said, today the majority of armed conflicts are of a non-international nature. We identified 3 international armed conflicts in the sense, if you want, in the literal sense of the words, i.e. Conflicts between states, but there are also all the situations of occupations that have been identified in the book, which are more or less the same as last year, with the exception of Ukraine. So those are also international armed conflict, as you know. So non-international armed conflicts, and my proposition to you tonight is to tell you that I believe that these conflicts are changing, the nature of these conflicts are changing, at least in 2 or 3 different ways. And I have been able to observe this not only through the course of my work at Geneva Call, but also in editing this book. So first of all, I think that one has to acknowledge that today there are less conflicts between armed groups and states per se. The more and more situation that we have been able to observe is that there are conflicts between groups. And this has an impact, not necessarily on the application of the law, on the determination of the law, that will be Common Article 3 application of the law, and not Additional Protocol 2, but rather also in the implementation of IHL, how to convince a group that they have to respect certain norms if their adversary do not respect them. So this is that argument can be made when there are states involved, and this is an argument which is made by many groups. But we have encountered arguments as such. For example, when we talk to some groups in Syria, who were not necessarily aware that the Islamic State were bound by IHL, and they were quite surprised when we talked to them that they were also bound by IHL. So when an armed group is facing another armed group, that also raises issues of the application of IHL.
Excuse me, I have just one question.
Sure.
Precision. Would you say that the Islamic State is still a non-state actor, or is it...
That's a very good question. In fact, this is also a point that I wanted to raise. What we understand as being non-state armed groups is also quite evolving. We cannot have an idea, we cannot only have one vision of what is an armed group. In fact, there are different type of armed groups or non-state actors, armed non-state actors. De facto authorities are one of these kind of actors. We consider that de facto authorities are non-state armed groups. It's not, from an analytical point of view, it's not very a good analysis, I believe. From a legal point of view, that doesn't make so much of a difference in terms of the application of IHL. It can make a difference in terms of the application of human rights law. Because there is a belief that human rights law is applicable to de facto authorities. Now, with the Islamic State, I think it's quite fair to say that the Islamic State is a de facto authority. As many other actors which are operating in the regions, like the Rojava administration or other type of actors. So, the second point that perhaps I would be interesting, I was interested to make in front of you was the idea that there is a change in the nature of the violence, and this is also something that we try to reflect in the war report. I think that today we are less confronted with classic, let's say, combat operations between armed groups and government, or even between armed groups themselves. What we see is, in certain contexts at least, is more violence, more direct violence against the civilian population. And I want to quote for you a thought by Professor Mary Kaldor. And she distinguishes between three types of situation, which I think are quite relevant. She believes that there is a blurring distinction between war, that she defines as, armed opposition between different actors based on political motives, rather. And there is also a blurring between war, organized crime, which is violence undertaken by privately organized groups for probably economic reasons, and then large-scale violations of human rights, which is violence undertaken by states or politically organized groups against individuals. And we have been able to witness this kind of violence, for example, in the Democratic Republic of the Congo or in the Central African Republic, where you have less armed combat between the groups, but rather unilateral violence against the population. And then finally, I think there is also what you just mentioned, the changing nature of armed groups, which are evolving. We have a multiplicity of the types of armed groups, which can be either highly organized armed groups and then will fall neatly into the definition of IHL. And then you have rather less organized armed communities, which also have a lot of impact on the civilian population, and here it can be much less easy to qualify the situation. For instance, you can have a very high level of violence, but a very low level of organization of the group, and then here IHL would not apply, and we would find ourselves sometimes in the situation not to know exactly which is the legal framework applicable. And in that context, like my last quote for tonight, which I thought was very, very interesting, that I'm taking from the International Crisis Group report on the Central African Republic, who has written a very interesting report on September 2015. And they have made the observation that today the conflict between the anti-Balaka, so in the Central African Republic, and ex-Seleka, is thus now compounded by a conflict between armed communities. And their report was aiming at talking about transitional justice, saying that it's just not enough to disarm armed groups. Now you must also disarm wider communities. And so the issue of transitional justice is one, but I think it also pushes us to think perhaps more openly about which legal framework really apply in those situations. In the war report, we have an article on transitional justice, but those were the few observations that we were able to make during the edition of this book.
There's one question about the situation in Central Africa, which illustrate the new forms of international armed conflicts. Would you say that it is a religious conflict, or
It didn't start as a religious conflict, and this is what this report is talking about. The roots of violence in the Central African Republic is quite complex, because it is a country which is in itself already in the middle of different very violent situations. And so there have been many changes of regimes with the creation of armed opposition, also like the ex-Seleka. And then slowly, the violence directed at the communities started to push people to organize themselves in self-defense group. And this is a non-state actor, if you want, those self-defense group, although they are very loosely organized and they don't necessarily have political motivations. And then when you have self-defense groups that's starting to organize themselves, the violence started to get at each other. And it's true, there are issues now of heinous actions against certain communities, but I wouldn't say it started really as a religious conflict.
And you said violence directly targeting against the civil population. Why this attack against the civilian?
There are different reasons. For example, to talk about the Central African Republic, those are countries which are really poor. And so the youth is really attracted. Sometimes it's their only way to get some form of resources. So in the Central African Republic, there was a huge issue of looting. But apart from this, there is the fact that armed groups attract people also to help them having access to some form of subsistence. And so this is one of the recommendation of this report, to say that you need also to cut the possibility of the armed groups to have access to some financial resources, so that it would also help the disarmament. So there are different reasons why there is violence directed against the civilian population, but that could be one of them.
And let's speak a little bit about the rise of the Islamic State, which is the very important event of last year. How to manage with this kind of groups which reject universal values, which reject the international humanitarian law or the human rights law?
Yes, it's an excellent question. We also have an article on the Islamic State in this book. I think that with regard to the Islamic State, we shouldn't have a static approach. There is a history that armed groups, very extreme armed groups, have evolved over time, and that was the case of the Taliban. When you look at the latest Taliban statement that they have done in response to one of the report which was issued by UNAMA, they have almost reproduced an IHL manual. Of course, it's not a pure IHL manual, and there are many issues that remain to be addressed. But this is to say that 10 years ago, the Taliban were the pure devil, in the international relations. Today, it's not the case. Now we have the Islamic State, and it's true. It's almost impossible to, I would even say, it might be absolutely impossible to talk to them. And I will give you an example. Last week, I talked with a very senior, very experienced human rights lawyer who used to go very often to Syria. And she told me that in 2013, still she was able to talk to the Islamic State, and since then she was not able to talk to them. And she told me that in her 25 years of experience, it was the first time that she couldn't talk to a group like this. But I think that there are windows of opportunities. We just need to wait for them. And according to how the conflict will evolve, the Islamic State would be perhaps much proner to some kind of dialogue at certain point of the conflict. That would be my position now. But of course, it is problematic at this very moment.
Thank you very much, Anissa Bellal, for your report. We are waiting, yeah. So the next report is about the conflict in Ukraine. Christophe Haynes, you're a professor of human rights law and co-director of the Institute for International Law in Africa at the University of Pretoria. Your intervention will focus on the conflicts in Ukraine. Please.
Well, first, just thank you very much, as other speakers have said, for this opportunity, and really also just to welcome the new publication. So, it seems to be a common issue, yeah. And congratulations to Anissa really for the what I think is extremely useful contribution, and in particular, as Robert has mentioned, the independence of that, and I think it's a very important voice. And it will be interesting to see if you are looking at ways of reforming it, how that goes, and the role that the web plays. But I can certainly say that from my perspective, it's a very important publication. Yes, my connection with Ukraine is in the context of my role with the United Nations as a special rapporteur on extrajudicial summary or arbitrary executions. And in that capacity, I do country visits. Normally the expectation is that one would do 2 country visits per year, and you go for, say, 10 days or perhaps 2 weeks to visit a particular country. I had the opportunity to go to Ukraine now in September of this year. And in that context, one then has the opportunity to meet with government officials. And in this case, there was a very open approach in terms of meeting with those in within the military, those within Home Affairs, the judges and so forth, and also the opportunity then to go across the contact line into the Donbas area, Donetsk, and other areas there, and see some of the consequences of the war as well. It was not possible to go to Crimea. Of course the issue there is access, and does one, if you're a guest of the government of Ukraine, that practically they cannot facilitate that. Theoretically, it's possible to go through Moscow, but to some extent, one then, of course, it's in a different it's a different kind of message that you send if you do that. So it was for myself and for other human rights monitors impossible to go to Crimea. I think to some extent, and picking up on what Anissa was saying about new kinds of conflicts, I think to some extent Ukraine can perhaps be seen as more in the traditional mold, where geopolitical aspirations of states come into play. The idea of orientation, as one of the government officials whom I met said, it was a choice of civilization or orientation, I would say. Is it a more Europe-centered approach? Is it a more Russian-centered approach? And really that provided the fault line. I think that both in terms of Crimea and in the eastern part, that in a way triggered the two conflicts. So on the one hand, there's the international armed conflict that occurred, and the occupation that continues in Crimea in March 18 March 2014, and the occupation that took place there. Not a huge number of fatalities that are known, but very difficult to know what's going on now in Crimea itself. And then, of course, the part that is under the separatist control, the two parts of the republics in the east, which the ICRC has described as a non-international armed conflict. And from just a little bit that I've looked at the war report, that I think to a large extent, and also the experience of on the ground in Ukraine to a large extent, that's the framework within which it's seen. Whether it has been internationalized to the extent of the involvement of Russia, that's difficult to say, and I think that's also the conclusion that the war report follows. But I think the bottom line is that in addition to human rights, IHL applies in that particular conflict. The report that came out yesterday from the Human Rights Monitoring Mission in the Ukraine, in addition to the OSCE, who has a very large presence there, there's a monitoring mission, says that during this conflict from roughly April of 2014, just over 9,000 people have been killed, much larger casualties in general, but just over 9,000 lives lost. What they emphasize in this particular report is that the Minsk ceasefire was really revamped, so to speak, beginning of September, and that's actually just when the mission took place. And I think 47 or so people in the last 3 months have been killed. So really a radical, at least over this period, a radical de-escalation of the conflict, largely because the heavy artillery has been moved from the contact line, which is just over 400 kilometers, about 800,000 people living affected by that. But to a large extent, the kinds of issues and the kinds of causes of death in that case has been indiscriminate shelling from both sides. What my report emphasizes is the lack of accountability, really, on both sides. So the normative framework is there in terms of the legal provisions of the state itself. That is in place. But there's really, when one talks to the military leaders as well, there's very little sense of follow-up when there are civilian casualties. But to a large extent, I would say, and perhaps I should stop there and see where the conversation goes, but I think to a large extent, perhaps what can be seen as more in the traditional mold than one would find in many of the other conflicts that occur today.
Yes, thank you, Christopher. And that the report notes a growing use of weapons like drones, for instance, what adjustment of the international law should be considered in this situation?
Well, I think my reports on drones are really in other contexts that it comes about.
But in Ukraine and Gaza, I suppose, no? Explosive weapons? Okay.
Yeah, explosive weapons and indiscriminate shelling, I think, have
Okay.
been well, indiscriminate shelling, I think, on those sides have been for a long time the biggest problem. But now the explosive remnants that are still there, landmines is an issue. I think there's something like 5 million landmines still
Excuse me.
so something like 5 million landmines that are still not destroyed. But I think drones are really in different contexts that they are used.
And an adjustment of the international law, it's possible, it's useful. We need that now.
Well, I think in the context of the Ukraine, it's almost a classical kind of situation where IHL is developed to deal with. I do think in other contexts with drones and with autonomous weapons and those sort of things, there may be needs for changing in the law itself. But I think in the Ukraine context, it seems to me it's the application of the law that is really the relevant part. And from my perspective as rapporteur of extrajudicial executions, it's focusing on the right to life. And they're really the two components. One is when may force be used, but in the second place, is there accountability if force has been used in the wrong way? And it is on both those elements of the application of the it's the application of the current legal system that I think is particularly problematic.
Yes, yeah, sure, and Isabella.
May I just step in? Yes, about the use of weapons also in the conflict in Ukraine and in Gaza, to which you alluded to. This is also something that we have witnessed in drafting the war report. Is not only us. I mean, it's also the work of different organizations, in particular Human Rights Watch and Amnesty International, who have done two extremely interesting reports on Ukraine and on the Gaza war of 2014, on which there is also an article in the war report. But I have to say that, so I believe there is also a slight change of explosive weapon, how we approach the use of explosive weapons in highly populated area. Because when you look at this a few years ago, the debate was really driven by humanitarian agencies, especially by OCHA. And the idea was really states have the right to use explosive weapons, including in highly populated area. So it's rather, we should rather address the humanitarian impact of this use, and not really talking about the legal aspect of this. And as you know, the legal aspect of the use of explosive weapons in populated area might be really twofold. First is how can we ensure that we distinguish between the military objectives and the civilian population, and how we can also avoid too much, let's say, collateral damages. And when you see at the picture of what Gaza looks today, you see that the city is entirely destroyed. So at some point now the debate is changing slightly also to the legal aspect of this, and saying, okay, how can we better assess the proportionality impact of the use of these weapons in highly populated area? And how can we also evaluate whether or not state or armed non-state actors that use those weapons do respect, in fact, the principle of a distinction and proportionality and precaution? So it is slightly at least this is my opinion, but I think there is here, it's not really a change of the law, but how can we ensure that we implement one of the most difficult principles in IHL, which is the principle of proportionality. So how can we better assess this principle when we look at the use of these weapons?
Thank you. You want to add something?
Well, yes, perhaps just so in the case of Ukraine, they've not ratified the Convention on Cluster Munitions. But in their comments from the state side, the criticism of the secessionists, of the so-called People's Republics, it seems that they accept the principle of distinction and of proportionality. And so if one talks about changing in the law to a large extent, I think the legal structure is there, but it certainly will be good if Ukraine also formally accepts that particular instrument as well.
Thank you. Perhaps I would like to ask you a question as a professor of humanitarian rights law. The attacks in Paris, Charlie Hebdo, now the recent attacks in Paris clearly show that a new kind of armed violence affect our society. What type of response for this kind of attacks or threat? What do you think? The Americans have the Patriot Act. We could have the same kind of legislation.
Yes, I think very, very sort of generally to say that I think in the first place one must recognize the legitimacy of action against the kinds of attacks that you've mentioned. International law is not pacifist. International law is not a suicide pact between states that they will not act. But I think it's very important to emphasize that the reactions to those kinds of attacks must be within the value framework of the international norms that we have at the moment. I think it's very easy to get into a mindset of this is an all-out attack. It's a supreme emergency. It justifies any kind of response simply to get rid of this particular threat. The danger of that is in doing so, you actually defeat the purpose that you want to do, which is to establish the basic norms that have been internalized in the international system. So I do think those two, in the first place, yes, the proper response and including use of force, but within the framework of laws that have developed really over centuries. And one can easily lose it when one wants to react to one particular incident. And in the end, you may say, well, we've lost now more than we've sacrificed what we actually wanted to protect.
And what do you think about the bombing of the coalition in Syria now? Is it legal? Is it the bombing of the coalition in Syria? What do you think about that? What can we say?
Well, I would certainly also be keen to hear what the other colleagues will say. But I think very generally, if one talks about the legality of the use of force, up to I think almost a dozen states are involved in one way or another. It can be in principle based on consent. I think it's really just in the case of Russia that they make that argument that they have consent, and there's some arguments about that. Self-defense, I think some of the big issues are there in terms of the use.
Is it self-defense?
Well, I think the issues that come up include whether one can act against a non-state actor and whether you can act in anticipation. But the arguments I think that are made by most of the states are that they're acting in collective self-defense and individual self-defense. I think Australia just says collective self-defense, but most of the others say that because of the 2014 September request by Iraq that they're really acting in collective self-defense. So I think it is probably changed from earlier times when the idea was that it's self-defense is only against another state. There seems to be much wider acceptance of the idea that non-state actors can also be targeted. I think there remain many problems around that. But it seems to be moving in the broader consensus that self-defense can be used against non-state actors as well. The third ground, of course, for use of force is if the Security Council adopts a resolution. And the Security Council has adopted resolution concerning the territories held by ISIS. But it's not a very clear resolution. It's not clearly under Chapter 7 that they've adopted this. It's not a decision that they've taken. They call on states to act. So it seems that they in a way say it's understandable if states do that, but it's not in the same language that is used in many other cases. But I think that the combination of self-defense and to some extent the signal from the Security Council, at least as far as that part of the law is concerned, may be an argument for the interstate use of force. There's a separate issue, of course, of what is the applicable law as when on the use of force itself.
Thank you, Christopher Ains. You want to add something?
Yeah, just a little thing about the self-defense, because I think that states have a tendency now to stretch too much this concept. Just one example, that the UK use a drone, I think, or at least targeted. They made a targeted killings of a UK national in Syria, invoking self-defense, just one person. So yeah, sometimes that is legally murky, I would.
Thank you very much. Yeah, I have now the pleasure to present Ms. Cordula Droege, head of the operational law unit at the International Committee of the Red Cross. You're with your delegation confronted daily with the application of the international law to the reality of the armed conflicts. Your report will focus tonight on contemporary conflict trends. Please. To push.
I'll do my best. Thank you very much. Thank you very much for to the organizers for having invited me to come. Congratulations to the authors, some of whom are in the room for the different chapters. It's been a pleasure for me because for the past 3 years, when the war report was discussed, I've been engaged in constant discussions as well with Stuart before Anissa and with Anissa about different conflicts and how we classify them and how complicated it often is. So I always look forward to reading which situations they have classified as conflicts and compare to how the ICRC might have classified them or not. Yes, I wanted to talk about this is strange, 3 aspects about contemporary trends. And I mean, there are many more, and also I think we have to be very careful when we talk about trends, because very often we create myths for ourselves about things that change that might not change so obviously, or where in fact when we look twice it might not be so evident that there is a trend. But some observations, let's say, one about the protractedness of conflicts and the effects on civilians. Second one about the geography and actors of contemporary armed conflicts. And the third one about the political atmosphere, for lack of a better formulation maybe. So about the protractedness, I think what we can observe is that almost all the conflicts that we see are the result of a conflict trap, which means they're conflicts engendering more conflicts, longer conflicts. We have a fragmentation of groups, so we have a multiplication of parties of ongoing conflicts, and we have more and more new actors becoming parties to those ongoing conflicts. And this protractedness makes it even more evident that civilians, and this is not a new trend in a way, bear the brunt of the humanitarian consequences of conflicts, and I think we must never forget this. They are the ones who suffer, their families go missing, they suffer, and this is very important, it was mentioned now, from the use of explosive weapons, because we have a tendency now to have hostilities occurring in urban settings or populated areas, just by the sheer fact of a growing urbanization of societies, also by the fact of course, that some belligerents like to hide amongst the civilian population or intermingle with the civilian population. Also possibly by the fact that, of course, some conflicts are about acquiring territory of strategic places, and those strategic places might be important cities. So again, conflict in urban settings. And this comes through in several chapters of the war report, actually, and I think is a very important and very disturbing trend. And I would agree with Anissa that there is discussion as well about the law surrounding the use of such weapons. And I think certainly when we look at the harrowing and devastating effects that those weapons have on the civilian population, then that poses very serious questions about how states interpret the existing norms, such as the prohibition of indiscriminate attacks or of disproportionate attacks. And we have to look at this very clearly. We also have to realize that there isn't one, there's quite a bit of divergence amongst military about what is acceptable or not in terms of what weapons to use in what kind of settings, and that also points to some ambiguity and maybe a need for states to clarify a bit more their interpretation of IHL. And the other thing that I think we really see in recent years is this terrible toll that these conflicts take on the civilian population also mean that they have to move from their homes and their communities into long-term displacement or exile. And as you know from UNHCR's figures, we have now the highest number of refugees that we've had since the Second World War. And that's, of course, something that really must give us cause for great, great concern. Also knowing that by those effects, the humanitarian sector is basically at a risk of breaking point. The gap between the needs and between what the humanitarian sector can provide is just not breachable anymore. And it's very difficult to be able to respond to the needs. There's also security questions, of course, about that. The other aspect that I think is interesting to look at in contemporary conflicts is the geography and the actors. I think we do see that the territorial span seems to be expanding. So we have a lot of spillover of conflicts. That's probably maybe the most traditional way of how conflicts expand. But a real regionalization, and I think we only have to look at the map of the Middle East to realize the regionalization of conflicts, but also further into the Sahel, for instance, around Lake Chad. These are all regional conflicts, not confined to the territory of one state anymore. And we also have a lot of foreign interventions. Foreign interventions seem to also be more the norm than the exceptions nowadays in contemporary conflicts, and not only interventions by neighboring countries, but also countries from across the globe. And that, of course, then creates enormous questions about where does IHL apply beyond the immediate place where hostilities are taking place. Does it apply in the sending states of foreign troops? What happens when non-state actors move into third non-belligerent states? Does IHL move with them in their rucksack or not? And these are unsettled questions in international law that are very difficult, but that actually do have a very practical bearing, mainly on the right to life, of course. On the state side, I think foreign interventions may be one of those things that we see as a trend. On the non-state side, I think, and Anissa mentioned this, we have a multiplicity of fracturing, splitting, reconverging non-state armed groups whose structure is very difficult to understand in many situations, which, as Anissa also mentioned, makes it then difficult to know whether they are actually organized armed groups for the purpose of the classification of a non-international armed conflict. So we're not always sure what type of law applies. And in the Central African Republic, for instance, that was one of the, I think, questions that many of those who worked on this conflict asked themselves. And I think the important, when we look at the humanitarian consequences of this multiplication, we have to be careful not to say things that are wrong. But talking to my colleagues who maybe analyze these things a bit, I think we can see some things that are very important for the civilians that are affected by this. The multiplication of actors means also a multiplication of front lines, very simply. And the multiplication of frontline means that civilians have a higher chance to be caught in the combat and in the fighting. It also very probably represents a greater strain on resources, be they natural resources or financial resources, because these groups or other actors need to sustain themselves. And they need to do this by, even raising tax or using the natural resources, etc. Also, of course, we have fractured communities, fractured families, people, civilians being associated with one or the other group, and this also means a higher risk of reprisal. And I think before there was also a discussion about violence against civilians, and I think very often it's also violence against civilians who are associated with one or the other parties to the conflict. And that's, of course, the more parties to conflict you have, the higher the risk that you will be associated with one of them on ethnic grounds, on the fact that you live in that area, because of the religious component, etc. The opacity of some of those groups and the lack of the chain of command, I think, means that we have not only, particularly for the humanitarian organizations, for instance, which want to work in those situations, security problems, of course. Although it does seem, at least in the ICRC, it doesn't seem to be the case that there's necessarily more security incidents lately. I find it difficult to say this because for me that's quite an emotional thing as well, because of course I think of my colleagues. But
you are still present in its area, for instance?
In some areas, of course, the ICRC is present, and these are difficult areas when you think about Yemen, when you think about Syria, when you think about the Central African Republic. Mm-hmm. I think we need to be very careful about analyzing this, but also what at least our president said was that it seems to kind of be taken for granted that humanitarians will be at risk when they work in those areas, and that's of course also a cause for concern, because ultimately if they can't work in those areas, it means the civilians can't be reached and can't receive the assistance and protection that they should be entitled to. And it also, when you have a lack of structure and capacity of the chain of command, it's very difficult to have a dialogue on what we call protection, so about respect for IHL and violations, possible violations, because you don't necessarily know with whom to engage and who might be able to influence the group, have the disciplinary structure, etc., in order to actually abide by the rules. And
excuse me, Cordula, it's
yes.
not the only lack of respect of the humanitarian law. For instance, we had this recent bombing of this hospital of Médecins Sans Frontières in Kunduz. What do you think? What is your what can you say about that sort of act? It was a war crime, second the president of MSF.
Well, as you know, I mean, our Secretary General, our President immediately, expressed condemnation of that, because it was very, it was a great cause for concern. We also had ICRC staff in that hospital, 2 staff in that hospital. I think we have to see it in the broader framework of attacks on healthcare facilities and on healthcare personnel. Of course, now there is a report that's been announced, but we haven't read this report, of course, by the United States. So I don't think we can pronounce ourselves on this as yet. But it seems quite clear that the United States themselves say that there's been a lack of precaution, which of course is an obligation under international humanitarian law. So that's of course problematic. Whether something is a war crime or not, I think, is really for a court of law to judge, because individuals are those who
for the international court, criminal court.
Well, for the International Criminal Court would be a bit difficult considering it's the United States. But of course, there is an obligation under international humanitarian law when you have a serious allegation of a war crime being committed to investigate that crime. And I'm sure that the United States, should they find that there is such an allegation, will hopefully take those necessary steps. The last thing I wanted to say about the multiplicity of actors is, of course, that it makes it more difficult to negotiate within the situation of the conflict. So negotiating truces, for instance, for evacuation of the wounded and sick, becomes more difficult if you have more actors that need to agree, let alone, of course, peace agreements. And we see, of course, that sometimes in peace negotiations, some of the actors which are really important are not around the table, which is not to criticize any initiative to have peace negotiations. Of course, I think any of them has to be welcome, but it makes it very difficult the more people you need to get to have an agreement with. And then lastly, something about the political atmosphere. One of the things that is, of course, a cause for concern is what I would call sort of various states of denial. So it's been mentioned, the denial by some groups, the outright normative rejection, as it were, of international humanitarian law. You've spoken about the Islamic State group. It used to be on the grounds of political, it could have been when it was seen as bourgeois law. It can be political, it can be religious. So that's, of course, very difficult then, because then it's not, there's no basis to engage normatively on that basis, which I don't think means, and I think you said it very well, Anissa, that one shouldn't engage with groups, well, those of us who need to do so or have a mandate to do so, etc. I think one then has to come back to the principles of humanity, to human dignity, find things that are true across the cultures, find the equivalent in those cultures in order to be able to have some way of finding some common language to talk about those things.
Do you think the Swiss government could take any initiative for the respect of the humanitarian law?
Well, the Swiss government takes many initiatives, I think, for the respect of humanitarian law, and I would not like to speak for them. I mean, we had, as you know, together with the Swiss government and the ICRC, a proposal to create a compliance mechanism for international humanitarian law. We've just seen today that states are not ready for that, which is, in our opinion, very disappointing and a missed opportunity. But on the other hand, if we want to see the glass half full rather than half empty, they have agreed to continue negotiating. And possibly in the political atmosphere that we have nowadays, that's more than nothing. And maybe we have to already, we have to work on that basis, because that's the political reality in the world today. Another type of denial, I would say, is within the counterterrorism discourse, and that's also a cause for concern, because you have many states which basically don't want to give legitimacy to groups that they consider to be terrorist groups, and therefore argue that they're not in a situation of conflict, but they're fighting terrorists. And if they applied IHL, this would provide a legitimacy to those belligerents. And I think there it's very important, be it for the ICRC, but also for other lawyers, to point out that under IHL, very explicitly, as said in Common Article 3, the application of IHL does not confer any legal status on any of the parties. And to remember that IHL is there to provide a measure of humanity in situations of conflict, as bad as they may be. And another type of denial that we see is just basically the denial of an involvement in armed conflict, particularly because we have quite a number of situations of maybe indirect support, maybe proxy wars, etc. And that's a real challenge, I think, for us, particularly as the ICRC, because of course we're not there to make an investigation about the military operations of states around the world, but we need to, of course, know what operations parties are engaged in order to be able to have a dialogue with them about respect for IHL. And that's difficult when there's a total denial, basically. So that's I think a situation that we also need to address. And then lastly, in terms of the political atmosphere, maybe this incapacity of the international system to maintain peace and security, which again leads me to my first point: protracted conflicts that don't seem to be ending. And what we've seen lately as well is that because of that incapacity, the discourse then shifts from resolution of the conflict to humanitarian aid. And sometimes that can have good results, because punctually you can then find agreements on truces or ceasefires, humanitarian pauses, etc. And we have to welcome anything that, of course, can help the civilian populations affected. or wounded and sick combatants. But there is also a risk that the politicization then shifts towards humanitarian access. And while, of course, the progress has to be welcomed, we also have to be a bit wary that this politicization doesn't basically go completely counter to the very object and purpose of humanitarian access, which is on humanitarian aid, which is meant to be completely non-political, impartial, and just serving the victims of the conflict.
I think, Cordula, in this context, it's very interesting to listen to the last intervention from Ms. Cécile Haptel about the fight against impunity. You're UN High Commissioner for Human Rights, and you're professor of international law at the Fletcher School of Law, and you have more than 20 years of experience working on humanitarian issues. So, your report.
Thank you. Thank you very much. Good evening, and first, I'm absolutely delighted to be here tonight and to welcome this report. I'm the legal advisor to the High Commissioner for Human Rights, and I greet my boss towards the video link tonight, but not the High Commissioner for Human Rights.
Legal advisor.
Legal advisor,
Yeah, sure.
Yes. Really, it's quite telling how much discussion we've already had on how many violations we see, violations of international humanitarian law in armed conflict, and also violations of human rights law. It's been really already indicated by several speakers. The impact of armed conflict is now almost tangible on individuals. That's not a new phenomenon, but maybe what seemed to be overwhelming in the last few years and even in the last year is really how much reports we get of atrocity crimes being committed. And that can leave us with a sense that what are we doing? Are we simply overwhelmed by these atrocities and by the fact that they're documented and that they come on our screen, on a daily basis, and at the same time then they come and they go and they're replaced by other atrocities? So I thought that it's important really to also think of that dimension of armed conflict, which is armed conflict as a theater in which different violations are being committed, and what do we do about it, and what really can actually be reinforced in terms of furthering accountability in this context. The War Report has a number of indication of those issues. There are two specific chapters that particularly deal with accountability. One is on the ICC, and then there is a great chapter on transitional justice by Valentina Cadelo. The author is here with us tonight. And she broadens the scope and really look more broadly at transitional justice. But when I was really thinking, do we really see, in fact, more violations, or do we have more reports of those violations, is, I think, an issue that we really need to discuss and to seriously consider, because it really leads us to really look at the glass being half full or half empty. It is certain that we have seen over the last decade, in fact, a huge trend in the documentation of violations occurring within armed conflict and outside, but certainly during armed conflict. Once upon a time, there will be a few occasional reports being published by NGOs, by the United Nations, and that would be the extent of the documentation of these violations and atrocities, or so-called international crimes. Nowadays, with social media, each one of us can be an actor in fact, reporting those violations, and each one can also have a very easy access to this. So there is a plethora of information that is there that certainly has an impact on our perception of how many crimes are really being documented. But I think that beyond the access to information that is greatly facilitated by new means of communication and new technology, it also has changed the very way we document these violations and the way they're being exposed, and possibly even the reaction to demand accountability. And by that, what I mean is that when organizations such as the Amnesty International, Human Rights Watch, Fédération Internationale des Droits de l'Homme, or the UN used to document the crimes, they will not only document them, but classify them. And in fact say, not only, you know, this is a terrible massacre, but to say this may amount to a war crime. This may amount to crimes against humanity when we look at the widespread or systematic character of the attacks in a certain area. That partly digested information and at least contextualized information set in legal parameters probably helped demand more accountability than the current format of information that comes very raw on a very daily basis and then is immediately replaced by more documentations that again come very raw, create a lot of reaction, but not necessarily taking a step back to rationally think of what is that crime. Does that really qualify as an international crime? And therefore, is there really a need to demand accountability? So my question would really be whether that increase in the information that we have is leading to a less insistent demand for accountability. And if that is the case, then we really need to pause and think and possibly come back to the basic of asking for accountability. You have already referred to the International Criminal Court, and we are very lucky in today's world to have a permanent, hopefully one day universal international criminal jurisdictions. But that should not really lead us to forget that the primary responsibility for accountability is incumbent on states. Each and every state has an obligation to investigate and prosecute, especially those crimes that are, those alleged crimes that are committed on their territory or by their nationals or against their nationals, but also others, and especially when war crimes, for instance, are concerned, or other allegations, tortures, and many other international crimes. And maybe we are slowly letting states go away with literally murder, and not only a single murder, but many, many murders. And so where is that demand for judicial accountability? Do we still have it? And is it really as insistent as it should be? I think that maybe the fact that we are so looking at the rise of new forms of actors on the international scene, then again referring to the discussions we had on non-state armed groups, maybe that is taking us a bit away from thinking about the responsibility of the states. I mean, even in contexts like Syria and Iraq and many others, and the Central African Republic, we see non-state actors, but we also see states, and those states still have obligations. And I think it's important to continue to insist on these obligations. As for the non-state actors, especially those that are de facto authority, they're far too prompt at wanting to take the attributes of states and start to do things such as exercising quote and unquote judicial functions. And that is highly problematic from a human rights law perspective, because when we do have groups such as Daesh and many others, Boko Haram and many others of different nature, exercising judicial function, between inverted brackets, they actually do so completely disregarding international human rights law. They're not states, they're not supposed to actually try individuals when they detain them, and when they carry out, when they can't detain them, they actually really are in fact abducting them. So there are all sorts of issues to do with the fact that it is highly difficult when they actually engage into state attributes and start to exercise justice. And really, that should not take us away or distract us from the obligations that remain the state's obligation in those contexts. It's particularly problematic because in all of those contexts, we see that judicial accountability, that courts of laws are the first ones to really be disregarded, be attacked, and be dismantled in context of armed conflict. And that leaves the most vulnerable among the population in dire need of any access to their right to remedy. And among those most vulnerable population, we constantly see ethnic or religious minorities, we constantly see women, and especially the less empowered women in their societies, and I'm of course alluding there to sexual violence and rapes that are so systematically committed in many of today's armed conflict. And I also think of children that are not only the objects and victims of sexual crimes, but of many other crimes and a whole range of violations committed against them, either specifically because they are children or just because they are among the most vulnerable because they are children. So in any case, they still pay a very heavy price.
Yes, Cécile, after your you directed the International Center for Transitional Justice Program of for Children, no? Can you explain what was your purpose and result, perhaps?
Yes, it really came from a realization that when we think of transitional justice, which is really which encompasses criminal accountability and judicial accountability, but is broader, and look at ways in which victims may also have access to truth-seeking mechanism, or may have access to specific reparations that are granted to them, that within all of those areas, it is extremely important to consider that children have specific needs because they are children, and that there are certain specific procedures that ought to be respected when engaging with children, but also that they are stakeholders. We actually tend, and they're really justiciables, they're beneficiaries of justice. It is too easy to forget that in many of the contexts where we have armed conflict today, we have about half of the population that is, in fact, under the age of 18 or 20. We have a very sizable part of the civilians in any of those contexts that we have already mentioned that are, in fact, children. They're not just a small group, they may be the majority of the civilians as such. And if we then consider that they are targeted alongside others, then every time there is a bombing in a city or use of any weapons prohibited or not under international law, the victims are likely to include at least half of them, half of the victims being children. And in addition to that, in certain contexts, children are specifically targeted because they are children. That is particularly the case, again, in terms of sexual violence, and many children, girls and boys, are actually raped in many contexts. But they also can be targeted for recruitment. And we see that, again, as being something that, unfortunately, many non-state armed groups, among those that we have mentioned, do very deliberately. And they do so because children are easier targets, and also because they can be much more, they can unfortunately be persuaded even more easily than adults to also be involved in terrible crimes. So making sure that children go from a position where they are marginalized and simply thought of as a small category to really the full realization that they also have a huge stake in any transitional justice initiative is what we try to really achieve. And I think that it has taken traction, and that there is increasingly discussion and recognition of the fact that children are important stakeholders.
Thank you very much. Do we have some time for some question on the public? Thank you to our panelists. If you have any question, if you want, take a microphone. I think we have a mic. No, pas de micro. Okay, no microphone. Okay. No, I think you can go on with your question.
Ask a question to Mr. Christophanis.
Perhaps a little bit loud.
Okay.
Okay, thank you.
It's a question about Ukraine, Crimea specifically. I wanted to ask you. So it's a question about Crimea. I wanted to ask you, what do you think about it seems to me there are two claims to self-determination in this conflict. One is the Russian-speaking population, which are supported by the state of Russia, but the other, the traditional people from Crimea, were the Crimean Tatars, and they also have a claim to self-determination. Do you have any information about what's happening now about that? What is your opinion about these two conflicting claims, I think?
Yeah, well, to the extent that I encountered this, it was to meet with some of the representatives of the Tatar community who are in Kiev. Obviously, were not able to go to Crimea, but they certainly the message that they conveyed was one that they feel targeted in the current situation, and of course also recounted particular incidents to which they have access, but to which we didn't have access from our side.
Another question, please.
Thank you very much. I'm Olga Kavon from the Mission of Ukraine. Thank you for this presentation, and As a Ukrainian, I'm very sad to see my country in your report, which is, with all respect, is very comprehensive research, that useful resource of information. I would like to thank Mr. Christoph Heinz for referring to the situation in Ukraine. And especially to mentioning of the 12th report of the Human Rights Monitoring Mission of in Ukraine, the UN Human Rights Monitoring Mission. And I would like to refer just to a small mentioning in press release upon the presentation of this report, and which indicates inflow of ammunition, weaponry, and fighters. This is cited from a press release. Weaponry, fighters from the Russian Federation into the territories controlled by the armed groups. I would like to just a small note that they are armed groups. They are not separatists for United Nations and for Ukrainian government. They are illegal armed groups. They are Russia-backed illegal armed groups which act in our territory with clear objective aim to undermine territorial integrity and sovereignty of our state. And I would like to pick up on the issue of qualification, taking the possibility of having such an estimated panelists. From what point of view, what perspectives for qualification or requalification of this particular situation, conflict, especially bearing in mind the real situation in the Security Council, which is blocked, paralyzed by this participation of the state, which is a permanent member of the Security Council, but committing aggression. Thank you.
And Isabella will.
Thank you very much for your intervention and for your question. Indeed, Ukraine was one of those situations that were difficult to qualify. For one reason, in fact. The reason that it was difficult for us to qualify, and I think that was something shared by many organizations, is the fact that even if there are strong indications indeed that Russia is, present at least in the region, we could not have access to the facts to clearly establish the link between Russia and the armed non-state actors involved in the region. And we are just scientists, so for us we could not have this type of situation. And in legal terms, to be able to qualify the conflict as an international armed conflict, you need to prove that there is a certain level of control from the state to the armed groups. And here now the case law might be a bit different from one case to another, but still you need to prove this level of control. And because we didn't have the proofs of this control, at least us, but I know that many others don't have the proofs, we could not say that we were in front of an international armed conflict. Now, perhaps, and this is why we qualify the situation as two non-international armed conflicts, such as the ICRC has publicly done as well. So, and here, this brings me to the second point. The second point that you raised was on the role of the Security Council. And here I'd like to emphasize that this is why also one of the reasons that the Academy issued such a report, not only in 2012, 13, and now the 14th edition, but that was also the role of the Rule of Law in Armed Conflict project that exists in the Academy for many years. The thing is that we cannot trust the Security Council to issue qualification of conflict for many reasons. First of all, as you say, because some of the states will, veto this kind of qualification. And second, because sometimes they just might be wrong in their qualification for many reasons, either because they are legally wrong, and that was the case in the Central African Republic, but also because they will, in some situation, issue qualification, in other they won't. So it's not uniform, and it's not. It's too political to be trusted, I would say. Although it can be an indication. So you should not, to put it in other words, you should not look at the Security Council to have a response to your question. I think that the good way to have the better way would be to in fact push for clear establishment of the facts and the role of Russia in relation to these armed groups, if ever that would be possible.
Any other question? Yeah.
My name is Thomas Unger, working at the Geneva Academy, and I will make myself now a little bit unpopular and maybe being a bit more controversial. Some might say that human rights and also international humanitarian law is in a deep crisis at the moment, actually. And some might say that we still kind of are a bit nostalgic, thinking back about the 90s, and the early 2000s, where actually human rights, after the Cold War ended, were big on the agenda, basically, and suddenly we saw an opening, and we had some success stories, in particular looking at Southern Cone countries in Argentina, in Latin America, where actually, accountability and human rights kind of worked, and there were successful transitions, so to say, from dictatorships to democracy, so to say. But let me mention two challenges, and which also came up in the discussions here, where I see that the deepness of the crisis. Look at the question of accountability and the question of transitional justice. It has been mentioned. Transitional justice has been described as kind of a concept addressing past human rights violations and violations of international humanitarian law through, for example, using prosecutions, giving reparations, doing some truth-seeking, doing some institutional reform. The concept of transitional justice has been kind of developed in post-authoritarian situations, but today it's applied in conflict and in post-conflict situations without really knowing whether these mechanisms, which are there to kind of look into the question of the past, are actually adequate to function in this situation. So we use basically a model which has worked somewhere else in situations, which have a much higher universe of victims, a much higher universe of perpetrators, and which are more transnational in nature often. So is this? Are we using the right pill, so to say, to cure the conflict? And then a second very controversial issue, in particular, saying this issue among like human rights experts and human rights activists and so on, is the question of the victim, basically. We present often in discussions here the victim as a complete neutral animal, which basically we can just, without looking into politics, without looking into the messiness of post-conflict or conflict situation, just help and just basically have a humanitarian, very neutral approach towards it. But looking at conflicts, there is no kind of conflict where you don't have a blur between victims and perpetrators. Say, for example, the Lord Resistance Army, which operated in the north of Uganda for many years. Some of the top leadership of these organizations have been child soldiers and later have become perpetrators. I mean, just to give you a controversial example to kind of spark the discussion a bit. Thank you.
Human rights in deep crisis. Two questions for you, Cécile.
Thank you, Thomas, for steering up the debate.
My opinion is,
on whether there are challenges today, certainly. Whether we should really look at the situation as being only bleak? Absolutely not. I mean, otherwise, why are we even here, discussing it? But I think that on your first question about transitional justice and whether we have any indication that transitional justice can actually work in context of conflict and post-conflict, when in fact the roots or the origin of transitional justice comes from the post-authoritarian regimes, and especially in Latin America. I actually would approach I would approach the problem completely the other way, because basically what you're alluding to is almost to say, okay, here we are doing a fantastic social engineering, looking at transitional justice as if we were doing it from up-down approach to transitional justice, when I would really take it another way, which is really based on the rights of individual victims that are really enshrined in different international human rights instruments in particular, but we also find them in IHL on the right to know and the right to really have some information on the whereabouts of, for instance, the missing. So we do find elements in international law, and in particular in international human rights law and also in international humanitarian law, where victims as individuals have rights, including the right to remedy, which takes a number of components, including the right to have access to a judicial remedy, the right to have access to some information, and I would really claim that it's larger and also includes right to non-recurrence, which is absolutely crucial, and then brings us to the element of justice and peace and the fact that some form of accountability is necessary to really have long-term sustainable peace and stabilization. So I really wouldn't take it from that sort of macro level, but much more coming from a human rights-based approach enshrined on the rights of individuals. And I would really claim that each victim as an individual and as a human really has to have the capacity to be able to really claim those rights, and that therefore that creates then obligations on state to really realize them. But we could certainly go into a large debate on that, but taking that approach that those individuals have rights and that therefore we should really push and work on making sure that individual victims have their right respected and fulfilled and guaranteed is an extremely important approach, and I think that it is sound legally. Whether then victims are simply victims and only victims, of course it's more complicated than that. Especially if we think of victims in terms of communities, because in all armed conflict the situation is messy. And it's very rare that you have the poor innocent victims that are really, and then the terrible perpetrators. It's too easy for the media to sometimes depict it that way, but it's in fact only really sometimes can only throw oil on the fire in terms of activating further conflict. But that said, when we move from the collective victim to the individual victims, then we do find that many victims are, in fact, purely victims. And I think it's important to recognize that. You are many civilians that just happen to be at the wrong place at the wrong time and have no real role in the conflict. And I think it's extremely important that, again, legally and morally, we keep then that distinction. Whether certain categories of victims, such as children that may have been forcefully recruited and then are manipulated into committing atrocity crimes, the so-called child soldiers, especially if we think of the ones like in Uganda or even today in Syria, whether they are half victim, half perpetrator, is, I think, something that we should defeat. They are primarily victims because they are first and foremost victims of certain crimes, and then as victims they have been manipulated into themselves participating in crimes. And it is important that we really take them as a whole and recognize that they are primarily victims, but also that they are not exclusively victims. And I think that that's important in their own interest. Not only is it important for the victims of their own, of those crimes themselves, but also for the capacity, maybe for these children, and including when they become adults, to have a chance to acknowledge their crimes, to have a chance to being exposed to what they have been committing, and for them, their victims and society as a whole to move forward. Sorry, you can see that's really something that I really strongly feel animated.
Could
Yeah, you can add something.
Yes, just very briefly, also to come back to, well, this issue of is human rights in a crisis, is there a challenge, but also to come back to something Cecile spoke about earlier, the accountability and the role of technology, and the fact that the so-called third generation of fact finders, that initially it was seen as the UN primarily, and then NGOs came in, and now everybody can potentially be a fact finder. I think that's very powerful, but it also creates a challenge and to some extent a potential, I think, to destabilize in a way the attention as far as accountability is concerned, in the sense that there's the digital divide. And if I look at as a very, not in the armed conflict situation, but the particular example of a police officer using excessive force in a particular country where everybody happens to have cell phones, that's on the screens all the time, and a lot of pressure on those in the human rights international community to act on that particular issue. And of course it's important in itself, but there are so many other incidents that are not recorded. And coming from Africa, that's something that's close to my heart, is that in many cases the very same thing happens to millions of people, but it doesn't register. And so there is, if one thinks about the future of humanitarian values, I think there is a danger that technology, which in some way with body cameras and all those things can play a role, that it can also distort the picture, and it can in a way occupy the limited attention span and the limited abilities of the international community, and the same in armed conflict, to those that are well reported, and to the detriment then of many others who, and so if one talks about accountability, I think a larger part of it, we often think about accountability almost as a legal process, but there's the factual process of simply making sure that those facts are available, and we may distort the whole accountability thing by latching on too much to technology as well.
I think we have time for last question. Yeah.
Okay, thank you. I hope this isn't controversial, but we'll see. It's also primarily for Professor Aptel with respect to international criminal law. I mean, I was really intrigued by what you said at some point. You mentioned that you seem to be flooded with information, that you receive too much information, and that it used to be packaged, I think, in a different manner, that it would be classified according to the type of crime, so different types of violations, war crimes, crimes against humanity, and now it's just too much information that's being thrown at you. I find that really interesting and surprising in a way, because I have the impression that actually what's going on is that we have a tendency now to classify everything as an international crime. There's almost this tendency to look for international crimes everywhere. So, for example, the Paris attack is not just a terrorist attack, a bunch of thugs running around and killing people. Potentially, it's a crime against humanity. And the question is, why would we want it to be a crime against humanity? It's almost giving them legitimacy, and making it something bigger than it is. And I wonder if paradoxically this kind of focus on international crimes, this tendency to look for international crimes everywhere, may actually paradoxically be backfiring, because we can't deal with it. There's too much international criminal law. The ICC is needed everywhere. It's not just needed for the most serious situations. We look to the ICC whenever something bad happens. So I would just be curious curious to hear your thoughts on that.
Thank you. I think that, as you rightly mentioned, it's a paradox, and I think that we've got two trends going on, possibly simultaneously. One is the fact that, when I said we, it's really we as the public, we in this room and we more generally, we are bombarded by information that comes relatively raw, to the extent that it is very, again, those social media and just pictures of massacres, of bombings as they occur. And that's what I mean raw, is that it really comes without then an explanation, without even the context, and without necessarily a qualification as constituting violations of human rights, a violation of IHL. So that's what I meant. We as citizens being bombarded by that sort of information. But I think that the paradox is there, that we have that trend ongoing, and in parallel we do have a trend which is one where everything is qualified with, yes, as an international crime very quickly. In fact, it's almost an over-dramatization that we have. And it's almost like if an ordinary crime, so to speak, will not be sufficient to garner attention. And so there is an inflation in the use of terms that we may see, which again then may lead to that feeling of us being overwhelmed by the amount of atrocities that are being invoked and presented to us as being atrocities or as being international crimes all the time. I think those two trends are ongoing. Whether at the same time we do see a difficulty with a court such as the International Criminal Court, certainly, but it's because our expectations of what the ICC as the International Criminal Court can achieve are hugely inflated. The ICC will never, in the best case scenario, be able to really deal with all of the international crimes, all of the alleged international crimes committed. It was not even designed to be that. It's designed to be a court of last resort, insisting on the fact that states have the primary obligations to deliver justice. And I think that, again, it's extremely important that we really ensure that states do take their responsibility very seriously and provide more justice.
Thank you very much. Perhaps I have a last question about you mentioned the use of rape, the sexual violence against women, for instance, in Kivu. The use of rape as weapon of war has been denounced for years. Don't we need an international court for that specific subject? Yeah. As a last question, a big one.
The fact that rape is committed in armed conflict needs to be assessed against a number of issues. There are certain rapes that are occurring or that are committed in the context of armed conflict that are really just rape that are opportunistic rapes. Mm-hmm. There are rapes that are really result from armed sexual violence, that really result from a quite deliberate policy, and hence it has been qualified by the Security Council as being a weapon of war. But we need to also remember that those rapes often do occur in contexts where there may have been prevailing rapes and sexual violence occurring even before the armed conflict. And what they may just in fact feed on pre-existing patterns that are very discriminatory for women in general. So we need to really be very careful because not every situation is necessarily equal. Whether rape and sexual violence should be prosecuted by different mechanisms, my own answer will be no. And I think that it will be terrible and may only in fact exacerbate the stigmatization that already occurred for victims of rape and sexual violence. I think that those victims of rape and sexual violence, survivors of those crimes, should not be reduced to their identity as survivors of rape and sexual violence. Far too often, especially in context of armed conflict, they may have been victims of many other violations. And in fact, in some contexts, they may really do want to have accountability and justice, but for the whole range of their violations. And so to avoid stigmatization and to really make sure that this is certainly recognized as a crime and investigated and prosecuted as such, but also not given undue attention vis-à-vis other violations, I will not plead for a specific court, but rather for it to be dealt as a crime.
Thank you. Thank you very much. Thank you to our panelists. Thank you for your attention, for your for your presence tonight with us, and Mr. Roth for last word.
Last word. Just to thank everybody, the people who assisted there, and you have seen that they are even able to improvise assistance when things don't work as they should. This day has been very busy for them. Thank you very much for being with us even tonight after a very, very busy day. Thanks to all the panelists. Thanks to Romain Jean for having moderated this panel. And you are invited to a cocktail next door and to read the whole report. I wouldn't advise for everybody because it's not inexpensive, to put it that way, but to read the war report as soon as it will be available for everybody, and to buy for the ones naturally who can afford this important work in their shelves. Thank you very much. Have a nice evening. And next occasion, but without, if I don't make a mistake, without live streaming, next Wednesday at the Maison de la Paix with Professor Marko Milanovic, professor at the Academy, who will also discuss some points in the actuality. Thank you very much. Have a nice evening.
Ça, c'est vrai, c'était pas très clair. Au bout d'un moment, je me suis dit...